rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is a time set for oral argument in Arizona Department of Economic Security versus Superior Court, our case number SA140058. Each side is allocated 20 minutes for argument. Appellant may reserve, or petitioner may reserve a portion of their time if you wish to do so. And if you wish to do so, you need to keep track of your time at the podium. Out of respect for counsel, I would ask that those in attendance please either mute or turn your cell phones off so counsel's presentations are not interrupted. We have reviewed the briefs. We appreciate the briefs and as well as the supplemental citations. We looked at those as well. We have conferenced the case both previously and this morning, and we'd encourage you to keep that in mind as you present argument to us. Proceedings are being recorded and will be posted in due course on YouTube. So please, as you begin your argument, please state your name and the party that you represent. And with that, let me start with counsel for petitioner. And ma'am, I apologize. I can't read the handwriting for.
Don Williams.
I'm sorry. Very well. Thank you. I saw another name there. You may proceed. Thank you.
May it please the Court, my name is Dawn Williams. I represent the Department of Economic Security. Also present with me is Tony Valadez from the Solicitor General's Office of the State of Arizona. Your Honors, when respondent considered the Matthews v. Eldridge factors and failed to consider the children's interest in this matter, he not only negated ARS 8-237, but also the entire purpose of the child welfare system in Arizona. By ignoring the children's interest in being free from this type of emotional trauma, he has, in a sense, allowed the parents to continue abusing these children. The parents who have already been adjudicated unfit parents in this matter and are now being permitted to call the children to testify and subject them to certain trauma.
Are you advocating that the trial judge or the juvenile judge committed a legal error, or are you arguing that some sort of abuse of discretion?
The court committed a legal error in failing to consider the children's interests when considering the Matthews v. Eldridge factors. If you look at the juvenile court's order, the court says specifically as to the first factor, the court finds the parent's fundamental liberty interest would be affected by a termination proceeding. And then in the second factor, again, cites to the parent's fundamental liberty interest. Nowhere in the order does the court mention or consider the children's interests in this matter. And if you look at Matthews v. Eldridge, the first factor is the private interest that would be affected. But when you look at Santoski v. Kramer, or even Arizona's case of Kent K., where Arizona has adopted the Matthews v. Eldridge standard in child protection cases, it indicates that there are private interests, plural, that are affected, and that includes both the parent's interest and the children's interest, because at the point of a termination proceeding, those interests are not aligned.
How would you have had the court balance the parents' interest with the children's interest here?
In this matter, because of the specific procedural safeguards that are inherent in ARS 8-237, the court could have balanced those interests by refusing the parent's request or granting the department's motion for a protective order to keep the children from testifying, because there was unchallenged evidence that the children would be harmed by testifying, even without the parents present in the courtroom. Father has never challenged that.
Is there, I think I've seen in the record a reference to evidence that the older son might be emotionally traumatized by having to testify. Is there something similar in the record regarding the younger son?
Yes. If you look at the testimony of Natalie Anderson, the younger child's therapist, which is actually cited, I believe, in the first appendix, the memorandum decision from the prior case, and will also be presented at trial. She has also indicated that both children would be harmed, but it's my understanding that the father has only actually requested that the older child be called to testify.
Counsel, I assume that you would agree that the parents have some due process right to challenge the evidence that DES would present? What is the nature of that hearing? How would you propose that the parents' rights be respected in that area?
Certainly, the parents do have a due process right, and that right is protected by the fact that they can challenge the hearsay witnesses or the documents that are bringing the children's statements into evidence. The only challenges that the father has made to the children's statements are as to their reliability, which more appropriately goes to the persons that are bringing forward those statements, how those statements were elicited, the circumstances under which they were provided. In addition, the statute itself provides that those statements are only admissible if they have sufficient indicia of reliability. In the event that the department is unable to show that the statements have those indicia of reliability, then the appropriate safeguard is to exclude those statements, not to require the children to testify. The statute also requires that the statements be limited to statements that are made about abuse or neglect perpetrated on that child. So it's not just anything the child may say that can come in, it's only very specific statements about abuse or neglect. And in addition, the parents are also able to present their own evidence. For example, the father has indicated the intent to call an expert witness to testify about why the children's statements may be unreliable. And if in so doing, the father demonstrates that the statements are not reliable, again, the appropriate response is for the court to exclude those statements. And it will be assumed that because this is being tried to the court rather than to a jury, that the court can exclude those statements in its decision making.
What is the effect of the mother's conviction on her rights in this proceeding?
The department still has to prove the grounds for severance. I think the ground of abuse is significantly easier to prove as to mother at this point now that she has pled guilty to child abuse, but the mother will still have all the due process rights of a trial if she chooses to exercise those rights. And in addition, the father, again, has not been convicted of any criminal offense, so the department will still have to proceed as to the father regardless. And there will still also be the element of best interest that has to be proved.
Thank you.
Is it conceivable under your view of how the law should have been applied here that the juvenile judge could have reached the same conclusion?
Given the uncontroverted testimony that the children will be harmed if required to testify, I don't see how the court could have come to that conclusion. Had the court weighed the children's interests in this, and given the fact that the only challenges that the father is making is to the reliability of those statements, that the father will have adequate opportunity to protect his rights by challenging all of the hearsay witnesses, those people that are going to bring forward the children's statements.
In other words, by challenging the reliability in other ways.
Correct. Correct.
Does that depend on what evidence ADS seeks to offer that's attributed to the children? In other words, are you advocating a bright line rule applicable to all cases regardless?
I think the bright line rule should be that the court has to consider the children's interests in not every case.
And I understand that, but I guess what I'm pushing you a little bit, not in this case perhaps, but in a case not unlike this that isn't before this court. You're not, I want to make sure I understand, are you arguing that if there is a demonstration that testifying for a young child would be injurious or could be injurious to that child, that no matter what the evidence is, no matter how the parents can or cannot challenge or critique or confront that evidence, that the child could never be required to testify?
As long as the evidence is that the child is unavailable due to the child's inability to testify for the emotional reasons, I think that's the case.
But let me ask you, was that the unavailability, is that, I didn't get that flavor necessarily from the briefing either here or in the juvenile court, and clearly under 804 in the rules of evidence there's a pretty crisp definition about unavailability, but perhaps I overlooked the record.
Well, it wasn't a big issue in part because the father never challenged any of the assertions that the children would be harmed by testifying. The father's only challenge was that regardless of that harm to the children, he had the right to call them as witnesses. And so there may be a case where the children, where this court's particular remedial measure of having the parents excluded from the courtroom, but the children still testify and be cross-examined by parents' counsel, that may be appropriate in some cases. Because we have specific testimony from the child's therapist that even that much would be harmful, at least to the older child, it's the department's position that in this case, the children can't be subjected to that kind of harm.
And is that because, help me understand, is that because they are unavailable under ARE 804, or is that because due process doesn't require that, or is that because it's a proper consideration under the due process analysis, or something else, or more than one of those?
I think probably all of them to some extent, but primarily in this case, the focus is the due process issue. And because the parents' due process rights are adequately protected in other means, and because particularly because we have this statutory scheme, and because the court is charged with protecting children from harm, that has to be a significant factor in the court's consideration. In any other circumstance, if a parent were to advocate for doing something that was known to cause their children harm, that would be grounds for removal or termination of parental rights. So for the parents to be asserting that they know that this will harm their children and they seek to do it anyway is something that should raise red flags for the court, and the court should have considered in making that analysis under the Matthews v. Eldridge factors.
Let me ask, and you've mentioned the statute, and I appreciate that, and it predates by years Rule 45E, which is sort of the juvenile court rule analog. Do you read Rule, or are you arguing that Rule 45E requires a showing of unavailability under 804 to be invoked?
No, that rule does not require a showing of unavailability, and I think that was considered in JD 7499, where the court specifically found that a showing of unavailability wasn't necessary under the statute. It wasn't considering the rule at that point, but under the statute it wasn't a requirement.
And let me ask also, and this is a question I'll ask your adversary as well, the parties have cited 4 appellate Arizona cases that don't seem to address precisely this issue. Do you agree with that assessment of those cases?
Yes. For example, JD 561 is probably the closest, but that decision predated the statute. And so it was never a consideration that there was express statutory authority for the admissions of these kinds of statements. Again, JD 7499 allowed for due process rights for parents to cross-examine witnesses that were called against them. In this case, the department has no intention of calling the children as witnesses. And in the Yavapai J9365 case, again, the parents were allowed to cross-examine children when their testimony went to the heart of the proof against the parents. And in this case, there is no testimony from the children at this point for them to challenge.
For your reading of 561, the only Supreme Court case by my math that has been cited from Arizona, did ADS call the child in that case? It wasn't father. I mean, we sort of know that, but I wasn't quite clear from my reading of that. And I couldn't figure out who else it would have been.
I remember if that case, if it was the department or if it was the child's attorney.
Okay. Probably the broader point is it wasn't the parent.
It wasn't the parent in that case. It was the department or the child's attorney or guardian ad litem, and I'm sorry, I don't recall.
Well, and I'm not sure the decision illuminates that, so I may be looking for something that just doesn't exist.
In this case, the department's biggest concern is simply the juvenile court's failure to consider the children's interests at all in this matter. The department had argued from the outset that it was the children's interests that needed to be considered the most in this case, not only because of the evidence about the harm to the children, but just because of the general responsibility of both the department and the court to look out for the children's welfare. And so without considering that, this court made a serious error in determining that the parents' due process rights required this type of confrontation or permission to examine or cross-examine these children, however it's going to play out.
So your argument is that the trial court made a legal error in not considering that, but I take it your position would be even if the trial judge did consider that in his discretion, continued to find that that the children should testify, you would still be here either way.
We would still challenge that. If the court did consider the children's interest and order them to testify, we would still challenge that order, in part because such an order really eviscerates 8237. It makes it useless. If a child is going to be called to testify about that child's abuse or neglect, no matter what, then there's no point in having this statute. And most states have enacted some sort of statute. Many states limit them to sex abuse cases, but most states do have some sort of provision to allow these statements because children do disclose these things to protected individuals, and they may not be as likely to disclose them in a courtroom. And so in order to not only preserve the children's emotional security, but also to ensure that the court's truth-finding duty is preserved, the states allow these types of statements, and they allow them under very specific, very narrow circumstances to ensure that the parents' due process rights are protected.
But that then is sort of half the equation, isn't it? I mean, then the question is, all right, if that happens, does due process require the parent to be able to call the children to testify? And from the cases, and I appreciate the cases that have been cited in your supplemental authorities, they've been very enlightening to the court. But I think about the only commonality in that, given the differences in local law, is that for some courts, they look to Matthews v. Eldridge to do the balance. There are all sorts of different, largely statutes in other states that don't read, at least I think, identically to Arizona's statute and resulting rule. So other than that constitutional floor or ceiling, depending on your perspective, those are helpful and instructive, but they don't seem to guide us to an answer.
I think the guidance that's provided is that in any case where the courts have examined that state's statutory authority, they've upheld that statute as long as there are some inherent due process protections, like there are in Arizona's statute, that requires a very narrow category of statements and that they bear that indicia of reliability. So as long as those types of due process protections are recognized within the statute itself, the states have consistently upheld those statutes as protective of a parent's due process rights.
So in that situation, we don't need to consider whether the children would be harmed. Your view is that if the statute is satisfied, the statements come in, and the parents would never have a due process right to call those children to the stand.
Well, that will depend on the indicia of reliability and where that's coming from. The department here intends to not call the children as witnesses and to instead provide those indicia of reliability through the hearsay witnesses. In some cases, it may be that the department would call the children to testify, and in that case, the department agrees that the parents would have a right to cross-examine the children if they were witnesses called against them.
But I don't read your petition as saying if the evidence satisfies the statute and the rule that you don't need to look at Matthews v. Eldridge. I read your petition as saying that Matthews v. Eldridge does apply and that it should and properly must include the best interest of the children.
Exactly. Exactly. If the court has no further questions, I'd like to reserve the remainder of my time.
Very well.
Thank you.
Thank you, counsel. Mr. Zurbriggen, is that close?
It is.
Okay.
It's dead on.
Thank you.
May it please the court. Good morning, honorable judges and counsel for the state. My name is Jeff Zurbriggen. I represent the real party in interest, in this case, the natural biological father. The father in this case requests that the trial order stand unadulterated, and specifically that this court either not accept jurisdiction, or if the court does accept jurisdiction, that it deny relief. Regarding the declining of jurisdiction, the accepting of special action jurisdiction is obviously highly discretionary with this court. Special action jurisdiction is not appropriate to readdress factual determinations made by the trial judge. Here I would submit to the court that special action jurisdiction is not appropriate because this is not a purely legal issue. It's not an interlocutory order. It's not an issue of statewide importance. It's not an issue that's repetitive. and it's not something that would potentially evade review in the future.
Counsel, let me ask you, with respect to the statewide importance, you've heard me ask your adversary whether any of the 4 cases answer this specific question, and it doesn't seem to me that they do, but I'd be delighted to hear from you on that point.
Judge, I would agree that the 4 Arizona cases do not directly address this very specific narrow fact pattern. However, they all clearly support the notion that the parents have a due process right to question through counsel. Maybe the parents aren't there, maybe it's in chambers, whatever other protective orders are in place, but they clearly stand, all 4 of them, clearly stand for the proposition that the parents have a due process right to cross-examine children in a dependency and in the severance arena as well.
Counsel, it seems like in general hearsay law that if a statement satisfies a hearsay exception, and it comes in that the opponent is certainly entitled to cross-examine the person who reports the hearsay statement, but they're not entitled to cross-examination of the person who made the hearsay statement.
And I understand the court's position. However, the issue as I see it is that, although it's not squarely before the court, is frankly that I believe that is unconstitutional. Nowhere else in law do we see the ability to cross-examine somebody not afforded to people whose major liberty issues are at stake. The state suggests that if they choose to call the kids, then the parents may get a due process right to cross-examine. That's not what due process...
Or if somebody else called.
Well,
I don't know who else that'd be.
Well, I guess the guardian ad litem or somebody could...
Right.
And Judge Thuma, the case that I cited, the JDC case out of Kansas, that was a Supreme Court dependency case, I would note. It did have quite a similar fact pattern in the sense that the court approved, under the Eldridge analysis, the parents' ability to cross-examine the kids. The hearsay came in, as you indicated, Judge Howe, through their state-specific statute. However, the trial court afforded the mother the opportunity to cross-examine. She declined, and then nonetheless brought the appeal. But that's where that's somewhat similar factually to this case.
And I understand that, and this is, and we've looked at the cases, and again, for the 3rd time now, I want to thank you for your supplements. But then there's dicta in that case that obviously supports your argument, but mother declined the invitation. The child never testified in
That's
that
true.
Kansas case. So it didn't hold what you're asking this court to hold.
Well, but it did state that that had the mother requested, she could have cross-examined, and she forwent that opportunity.
Right. And there is discussion, absolutely. I mean, that's a fair characterization. It's just the court didn't have to decide that.
I would agree with the court. This is a very unique factual pattern. But I would submit to the court it's one that not necessarily we need to address here at the Court of Appeals, in the sense that, from my perspective, the proper standard of review here is abuse of discretion.
Counsel, correct me if you disagree. I think we all agree that the parents have some due process right to challenge the evidence presented against them in the termination proceeding. The question is, what is the nature of the proceeding? What is the nature of the evidence that is such that simply being able to challenge the testimony isn't enough? That you have to have a confrontation right or a right cross-examination? What is it about the evidence here that requires that you have cross-examination if you're otherwise able to challenge the evidence?
Well, I believe that the ability to collaterally attack those statements, not through the kids, is compromised and limited in the sense that you can only go through the procedures used. We have one video of a counseling session. None of the other counseling sessions were recorded. We have no audio or video of any of the discussions. So we don't know specifically what these folks have said or not said. What we do know is that there are a high number of inconsistencies in the statements. Angel wants to go home. He doesn't want to go home. He initially denies abuse twice to a forensic interviewer, and then subsequently over time with some discussions with foster parents, he starts allegedly disclosing.
Well, so you, in your answer, you've highlighted the circumstances that would call the statements into question. What's being added by having the children on the stand? You seem to be making a pretty decent argument that the statements aren't reliable. What's added by having the children subject to cross-examination?
Well, child abuse statements are a hard bell to unring. Once it's out there, it's very difficult and problematic to address collaterally. Even if with a recantation or some issue with the reliability of the kid's statements, it's still something that's it's palpable. It's one of those things. But it's just an added layer of protection for the parents to be able to have their kids on the stand, ask them, kids, they're concrete thinkers. Things that they say have to be viewed in context. There are many issues with regard to children's perspectives which are different from adults. As an example, one of the alleged statements that Angel made was that father covered Roman's mouth. Well, that sounds bad. What actually the reason for that is he was on a conference call and he covered his mouth because he wanted the little boy that was saying shh. So it's context. And having the children up on the stand to explain what they meant, to clarify inconsistent statements, and to specifically testify, as the counselors will for the state, to testify in an unbiased manner what procedures were used, what things were said, by whom. There are statements by counselors, by foster parents, by doctors in this case, to these kids, by medical personnel. And so getting to the heart of what was said, why was it said, who asked you about that, or who suggested that you said that. Those are the items that I think you can much thoroughly explore through cross-examination.
And so in your view, the psychological trauma to the children just doesn't matter, that your client's due process rights are so important, and that has to be respected?
No, sir. It certainly needs to, there are all issues that need to be addressed under Lassiter and under Eldridge. And that's what Judge Bean did. And in this case, Judge Bean clearly considered the kid's best interests. If you look at the state's motion to reconsider, it's Appendix 14, Exhibit 14, the state's motion to reconsider, the AG at the trial level specifically raised the best interest issue and alleged that Judge Bean failed to address the best interest issue. Judge Bean read that motion and he declined. So that argument, I think, fails here before the court.
But what we have is really the most full view of what the trial judge did was the pretty detailed minute entry doing the weighing and the balancing in addressing the motion for protective order. And it seemed to, from my read, that minute entry addressed best interests or concerns of the children only after finding that parents would be allowed to call them and then put processes in place, but not in we've called them the Matthews v. Eldridge factors, but not in weighing and assessing those.
And I understand the court's perspective, and I can see why the state is arguing why it's arguing, although I respectfully disagree. The reason is a former retired judge once told me, You have much less opportunity to be reversed on appeal if you don't say anything as far as your reasons why you made a decision.
Well, and I understand that
And-
train of thought, but and we're asked to parachute into a case that you have been all involved in for literally years. But what we have as indicia of what the judge meant was that writing.
Well, and you know, at its core, this case is about deference to the trial court. And cases such as Hutcherson and Ritchie specifically state the trial court's in the best position to weigh the issues before the court. Case law also under Glaze v. Marcus and Cross v. Cross state that we will affirm the trial court decision if it's correct for any reason, even if that reason was not considered by the trial court. There's great deference, and just because Judge Bean put a couple major reasons for each prong, for example, doesn't mean that he failed to address or think about or consider the other issues that he summarily rejected and just didn't write about.
And I understand your perspective on that, but to follow down that path would require this court to effectively reweigh on a limited record to see if the destination was correct, even if the path wasn't. And I don't see how that's a proper thing for this court to do
And that-
on a special action. Now, I'm sorry, you were going to.
I'm sorry for interrupting the court.
No, because I have a couple clarifying questions that I wanted you to address, but I'd be happy to hear.
Well, I was just going to say you said that better than I could have. That's part of one of my points as far as declining jurisdiction, or if you do, rejecting the claim, because we don't have a record. We have not had an evidentiary hearing about this issue. We don't have any established facts. We don't have anything subject to cross-examination at the trial level. These are just many documents among thousands of pages of documents that Judge Bean has looked at, considered, and I think it's highly inappropriate for a reweigh. And that's, in my opinion, what the state's asking this court to do is something that this court is fairly adamantly against, which is substituting its judgment for that of the trial court.
Let me ask you those clarifying questions that I had. This all started with the motion for I shouldn't say this all started. Procedurally, this issue arose with a motion for protective order under 26C, which I get from the parties' briefs. The parties agree that standard is an appropriate standard for protective order, recognizing there's a whole bunch more involved with when your client raised the due process concern. But you don't take the position that 26C doesn't apply here. Is that
I have
fair?
not briefed that
Okay.
issue, no.
Well, but just
Or taken that position.
fair enough. And then the other question I had is there's a great deal said in front of the trial court in the record that we have about, I'll refer to the older boy as AB, but not much on RB. Is the motion for protective order, I think, sought a protective order as to both children. The response, which we've read, it suggested that your response applied to both children. I've heard initially from the state that really the primary focus here, and perhaps the focus, is with respect to AB. But that's a point of clarification, if we can get clarification, that I would welcome. Is RB at issue here as well?
Yes, sir.
Okay.
He has made statements that are negative against the parents. And he has included it, I believe, in the court's order because it references children.
Let me ask you, the Rule 45, which is unique to the juvenile court, although there are analogs in other states, 45E, with respect to statements of abuse, does not contain a cross-examination text. Textually, the rule doesn't say that. Two other subparts with respect to the caseworker and respect to, I'll call them therapists, but it's broader than that, does talk about a cross-examination right. What meaning, if any, are we to give to that distinction?
Well, this court's required to read the rules as they're written, specifically as the legislature has enacted them, and try to stick to what the words say. There is no preclusion for cross-examination with regard to children's statements. There's no law, there's nothing contained in that text that precludes the ability to call a child, cross-examine, or direct examine by any party in the case.
And you're
dependency or severance.
You're absolutely right. And the question I have is really kind of the flip side of that.
Right.
What should we take that there are two other rules that says, hey, you don't get, these are hearsay exceptions. The hearsay doesn't come in unless the witness is subject to cross-examination.
Right. And I disagree with the state's proposition that to allow cross-examination would make that rule meaningless. I would submit to the court that that rule is one of convenience as opposed to something that's one of preclusion. So in other words, there are certain things that we hear about and we see all the time in juvenile court: abuse statements, neglect statements, caseworker reports, things of that nature. That's what the rule encompasses and allows for those things to come in. But then it says nothing about, you know, all the other issues as far as cross-examination. There's no preclusion there. Obviously, there's no confirmation of it either, but I think the case law provides that.
So your position in that respect is you're not taking a challenge to 45E or the statute. You're just saying for those provisions to apply and be constitutional to meet minimum due process requirements. In this case, your client has a right to call the children to cross-examine and confront them.
Well, I don't think that I personally take issue with those rules. I don't agree that they're fair to parents. However, I don't believe that that issue is squarely before the court. If the court rules against father in this case and we're not allowed to call the kids, my next trial motion would be one for motion in limine to address the issue of whether these things should come in or not. And then
it seemed to me your response to the motion for protective order made that pretty plain. That
right.
Okay.
And then at that point, I would challenge. I think at that point, the issue of constitutionality is squarely at issue, assuming that I would brief it that way.
What are we to take from the fact that severance trials have been going on for dozens, decades of years, and even both before and after the statute and this rule? Apparently, those have occurred without this issue arising, or at least without it being raised directly in a special action or an appeal, and that many severance trials have proceeded to final resolution without this issue arising.
Well, I think that, obviously some people don't appeal or file special actions. I think in some, I've had trials where I've called the children to the stand and they've testified and they've done fine, and it's nothing like what the state's describing. So I think these things happen. They just haven't, and haven't been squarely presented with this factual history that this case has. But the other 4 cases cited in Arizona clearly have those elements and clearly stand for the position that due process affords the parents right to cross-examine. So in conclusion, I would ask the court to focus somewhat on what the state has said in their own pleadings. The state's appendix 14, page 203, the Attorney General stated in his motion to reconsider that the trial court, quote, properly considered the 3-pronged test enunciated in Matthews v. Eldridge to determine the extent of the parent's due process in termination proceedings, unquote. So in its own pleading, we have that the state agrees that the trial court did properly evaluate the law. And I would note for this court, Judge Bean had everything that we had in this case. He had all of the law, maybe not the supplemental citations, but he had all of the Arizona law. He had all of the factual background. There has to be some deference and presumption that he's addressed everything, and he did have a fairly detailed admitted entry, which I think further reflects that. And the best interest issue was raised by the state, as I noted in their motion to reconsider by Judge Bean, and he specifically rejected it. I would also note in the state's special action brief, page 20, footnote 6, they stated, quote, forcing the children to testify, on the other hand, could lead to an erroneous decision. RB is very young, and AB is still fearful of openly discussing his past experiences, even with his own therapist. So we have the state here in the Court of Appeals realm acknowledging that what these kids have to say, even on the stand, which is presumably, hopefully, the best place to get an unbiased statement, these 2 kids in particular produce unreliable statements. So in conclusion, I would ask the court to affirm the trial court. Sorry.
Thank you.
Thank you.
Ms. Williams.
If I could, I'd like to address a few of counsel's statements. First of all, I would note for the court that the Arizona's courts have already upheld a hearsay exception for the social studies that are required to be prepared for a termination petition. So the courts have already looked at whether admitting a document under the hearsay exception was an appropriate exercise of the legislature's authority and of the court's authority, and found that it had. I would also acknowledge that the JDC case out of Kansas that was in both parties' supplemental authority indicates that a parent has the due process right to cross-examine a child if the child is available. And in this case, arguably, these children are not, given the type of harm that would be caused if they were required to testify.
Counsel, the argument has been made that Judge Bean did consider the best interests of the children and found that cross-examination was still required. Do you agree with that? And if that's the case, then we're just looking at whether the judge abused his discretion in deciding what he did.
I do not agree with that assessment. I think that the court's written ruling is clear that the court did not consider the children's interests until after it had determined that the parents' due process rights required that cross-examination. And then the court instituted some ameliorating circumstances to try to minimize the harm to the children, but did not consider those interests when it looked at those Matthews v. Eldridge factors. And I would dispute counsel's claim that the state's brief said that the court properly considered those factors. What the court properly considered was the use of Matthews v. Eldridge et al. To weigh these types of competing interests. And so the court did properly look to those factors, but didn't apply them correctly because it did not look at the children's interests. I would also dispute counsel's statement that children's statements on the witness stand are the most reliable evidence that they can present. Several of the cases that were cited in the department's supplemental authority indicated that children's statements on the stand are often not reliable, that because children in making these hearsay statements are spontaneously disclosing to trusted individuals, those statements are often more reliable than the type of statements they may make under vigorous cross-examination, because they are children and they can't be treated like adult witnesses. And so, but again, those factors all go to the reliability of the children's statements. And those are the type of things that father is able to challenge on cross-examination of the state's hearsay witnesses. So enabling father to challenge the reliability of those statements protects his due process rights without also subjecting the children to harm.
Thank you, counsel. Any other questions?
Thank you, Your Honor.
Counsel, we appreciate your argument. We appreciate your briefs, and I'll say it for the fourth time now, we appreciate your supplements as well. We will take this matter under advisement. We'll issue a written ruling in due course. Again, with the thanks of the court, we stand adjourned.
the actual pictures or just the cups?